In this lecture, we would like to discuss the most important and vital doctrine of the Constitution of India, that is the doctrine of basic structure. And this basic structure or basic framework is as important to Indian Constitution, so also we found its importance in other important constitutions of different countries that we would like to discuss. So the very meaning of the basic structure in very simple terms, the doctrine of basic structure suggests that certain parts of the constitutions of the world, it forms the core, having intrinsic value, and hence they cannot be altered or removed from the constitution. Such parts form the basis and reflects the principles of the makers of the constitution. Not only that, they also threw light on the basic tenets of constitutionalism and hence referred to as the basic structure or basic framework of the Constitution. The doctrine has been formulated by the judiciaries in the different legal systems in the world as well as the Indian judiciary through various cases as elaborated below. So, in India, the basic structure doctrine has been promulgated through a series of judgments, including the renowned case of Keshavananda Bharati versus State of Kerala, where the very beginning was made by the apex court by evolving the very doctrine of basic structure of Indian Constitution. Thus, the basic structure doctrine does not have a limited scope. The application of the doctrine has evolved only through the judicial interpretation of the Constitution. The Honorable Supreme Court and the High Courts, through their writ jurisdiction as provided under Article 32 in relation to Supreme Court and Article 226 in relation to High Courts. They intervene and interpret the Indian Constitution to impart its true meaning, scope, and application. However, the question that needs a proper response is whether the doctrine provides the judiciary an overhauling power over the legislature. A brief overview of the doctrine, along with the timeline of cases discussing the doctrine and the presence of such provisions under the constitution of other democratic countries forms the very scope of the present lecture, that on doctrine of basic structure that we would like to discuss. So, in relation to that, we would like to go to the very doctrine of basic structure as we found by our research in relation to other constitutions of other democratic countries. So the basic structure doctrine can be explained as part of the constitution which cannot be amended by the parliament. So, in relation to that we want to go to the Constitution of Germany. So the German Constitution, known as the Basic Law for the Federal Republic of Germany, is one of the prime examples of the constitutions which includes the doctrine of basic structure. So, Article 39, Clause 3, which under the amendment of the basic law states that the amendments to this basic law affecting the division of the federation into lander, their participation in principles in the legislative process or the principles laid down in Article 1 and 20 shall be inadmissible. The Constitution has defined the basic structure under Article 1 and Article 20 of the German Constitution, which has safeguarded the same by excluding it from the scope of amendments. So, Article 1 of the German Constitution regarding basic law provides that a human dignity shall be inviolable and the German people shall have inalienable human rights. Moreover, it is the duty of the state to protect the human rights of the people. So also, Article 20 provides that the Federal Republic of Germany shall be a democratic and social federal state. This German Constitution has laid down the basic structure in express terms, and it was only possible after the Nazi rule under Adolf Hitler ended in 1945 with the end of the Second World War. In order to avoid any similar situation again, the Federal Court of Justice, the apex court in Germany, recognized the provisions envisaged under Article 79, Clause 3 and referred to it as the constitutional identity in the renowned Schilling 1 and Schilling 2 judgments. Thus, the basic structure in Germany is now known as the constitutional identity of Germany. So, now we'll go to the French Constitution and Article 89, which relates to republican form. Similar to German Constitution, the Constitution of France expressly limits the powers of the government to amend the Constitution. Such limitation is expressed under Article 89 of the Constitution of France, which was made in 1958. The provision, apart from the procedure for amendment, states that the republican form of government shall not be the object of any amendment. Thus, the structure of the republican form of government is the basic structure provided under the French Constitution and is protected from any amendment by the French government or French parliament. So now we will go to the Greek Constitution and the very provision under Article 110 relating to parliamentary republic. The Greek Constitution also expressly protects the basic structure like the German and the French Constitution. Article 110 of the Constitution provides for the procedure of revision. It states that the provisions of the Constitution shall be subject to revision with the exception of those which determine the form of government as a parliamentary republic, and those of Articles 2 of paragraph 1, Article 4 paragraph 1, Article 4 and 7 shall show, Article 5 paragraph 1 and 3 and 13 and 26. Thus, the basic structure of the Greek constitution is provided under these provisions and are safeguarded by Article 110. And now we'll go to the Portuguese constitution regarding basic structure as provided under Article 288 of the Portuguese constitution, which relates to limitation on constitutional revision. The Portuguese constitution also provides explicit provisions for protection of the basic structure of the constitution. Article 288 enlists 14 limitations on the constitutional revision. These include the national independence and unity, republican form of government, separation of powers, citizens' freedoms, rights, and guarantees, independence of judiciary, etc. And now we'll go to discuss about the doctrine of basic structure in our neighboring country, that is Pakistan. So the very position in Pakistan that we would like to discuss from an important leading case, and that is Muhammad Khan Ashkaji versus Federation of Pakistan. As under 1997, Pakistan has followed the steps of India while promulgating the basic structure doctrine. In Pakistan, the question regarding limitations on amendments to the constitution were raised after Keshavananda Bharati decision in 1973. However, the question was raised by the Supreme Court of Pakistan in this important leading case, Muhammad Khan Ashkaji versus Federation of Pakistan. In 1997, the issue before the court was constitutional validity of the amendment allowing the president to dissolve the National Assembly. This provided an opportunity to the apex court to pen down the basic structure doctrine in Pakistan. This decision, however, was overruled by a larger bench within a year. The question regarding the basic structure was again raised before a 12-judge bench in 2015, which held by a majority decision in the case of District Bar Association and others versus Federation of Pakistan in 2015. The court held that this court is vested with the jurisdiction to interpret the constitution in order to ascertain and identify its defining salient features. It is equally vested with jurisdiction to examine the merits of any constitutional amendment so as to determine whether any of the salient features of the Constitution has been repealed, abrogated, or substantially altered as a consequence thereof. Thus, the court held the democratic and parliamentary form of government along with independent judiciary as a part of the basic structure of the Constitution. So, now we'll discuss the very basic structure and the Indian Constitution. So, in relation to that, we would like to discuss the very concept of basic structure as evolved through various important and vital decisions of our Supreme Court, which laid down, which were falling under the concept of basic structure or basic framework of the Constitution, such as the preamble, the democratic and republican character of the Indian Union and states, the secular nature of the republic, the fundamental rights as we found under Part 3 under Article 12 to Article 35 of the Constitution, so also the judicial review as given under Article 32 of the Constitution of India to the Supreme Court and Article 226 in relation to the states' high courts. So, also the independence of judiciary. So many such concepts of Indian Constitution are falling under the very ambit and scope of basic structure as evolved by the apex court on the decision of Keshavananda Bharati versus State of Kerala. So, the very evolution of the doctrine is important to be discussed with these important leading cases. So, we would like to discuss the first most important leading case, which evolved the very concept of basic structure or basic framework of the Constitution, is Keshavananda Bharati versus State of Kerala in 1973. In this case, turned out to be the longest judgment in the history of Indian legal system and also laid the foundation of one of the most imperative doctrine, and that is the basic structure doctrine. Here the petitioner was the leader of a religious sect in the state of Kerala. He held some of the land of the sect under his own name. Government sought to acquire a part of such land immediately after the Goloknath case of 1967. The 24th Constitutional Amendment Act was passed to nullify the effect of the judgment. The amendment provided that Parliament had the power to amend or modify any provisions of the Indian Constitution without being hit by Article 13 of the Constitution. Thereafter, a series of amendments on the basis of 24th Constitutional Amendment were also passed to nullify the Goloknath verdict tendered in 1967 by the apex court. Hence, the petitioner approves the Honorable Supreme Court contending violation of Article 25 and Article 26, which deal with right to practice and propagate religion and right to manage religious affairs respectively. While the petition was still pending, the Kerala Land Reforms Amendment Act 1971 was passed making amendments in Kerala Land Reforms Act 1963, and it was placed within the ambit of ninth schedule of the Constitution, which was inserted under the first Constitutional Amendment Act 1951. So all those acts placed under ninth schedule are beyond judicial review. Thus, the said law was also challenged in this case by the Kesavananda Bharati, the case of the largest constitutional bench of 13 judges to decide upon the matter. In pursuant to 68 days of hearing, the verdict of the case was passed. The court opined that the wide powers of the Parliament under Article 368 of the Indian Constitution were subject to the basic structure, doctrine. Any component forming part of the basic structure was not open to amendment by the legislature. Justice S.M. Sikri states as follows. In this important leading case, the true position is that every provision of the Constitution can be amended, provided in the result the basic foundation and structure of the Constitution remains the same. The basic structure may be said to consist of the following features: supremacy of the Constitution, the republican and democratic form of government, the secular character of the Constitution, separation of powers between the legislature, the executive, and the judiciary, the federal character of the Constitution. The basic structure is built on the basic foundation, and that is the dignity and freedom of the individual. This is of supreme importance. This cannot be, by any form of amendment, be destroyed. The Supreme Court also said that preamble was an intrinsic part of the basic structure, as it is the basis of Indian Constitution and envisages the fundamental rights for all the people. The court also established the golden triangle consisting Article 14, right to equality, and Article 19, all the fundamental freedoms, and Article 21, right to life and personal liberty of the Indian Constitution, as the golden triangle, and held that the same bounds the Indian legal system. The judgment acted as a cornerstone of the Indian Constitution, which secured the rights of the people and ensured that the amending powers could not be asked by the Parliament to get political gains. It resolved the essence of Indian democracy and ensured that constitutionalism continues to exist in the country. And now we'll discuss another important judgment relating to this leading case, Indira Nehru Gandhi versus Raj Narayan in 1975. After the Kesavananda Bharati case, which laid the foundation of basic structure doctrine in India by holding that certain parts of the Constitution cannot be amended in any manner. So, in this important leading case, the facts were such that the Allahabad High Court has invalidated the petitioner's election owing to corruption and malpractices. As a consequence, the Parliament passed the 39th Constitutional Amendment Act to invalidate the judgment. The amendment provided that the President, the Vice President, the Prime Minister, and the Speaker of the Lok Sabha could not be subject to judicial review, thereby nullifying the effect of the Allahabad High Court judgment. Eventually, the amendment was constitutionally challenged, contending whether it was permissible to nullify the effect of the judgment and also affect the procedure concerning elections. The Supreme Court held that free and fair elections form part of the basic structure doctrine, and hence the clause was held to be invalid. Further, the court added a few more elements to the doctrine, one of which was democracy, implying free and fair elections. Other elements included judicial review, rule of law, and Article 32 empowering the Supreme Court. And now we'll discuss another important judgment relating to the doctrine of basic structure is Minerva Mills versus Union of India in 1980. The issue of basic structure was raised before the Honorable Supreme Court regarding the constitutional validity of Section 4 and Section 55 of the Constitution, 42nd Constitutional Amendment Act of 1976, which transgressed the limitation of amending powers of the Parliament. The Parliament, by way of 42nd Amendment, introduced Clause 4 and Clause 5 to Article 368, which is the amending article of the Constitution of India, which in essence excluded the amendments to the Constitution from being subject to judicial review, and provided the Parliament an unrestricted power to amend the Constitution. The Supreme Court held that in India the supremacy of the Constitution is the most crucial aspect. The power to amend the Constitution provided to the legislature thus cannot be an absolute one, and it must respect the basic structure of the Constitution. If an absolute power is granted, the amendments would be outside the scope of judicial review, in which case Article 13 would be a dead letter, as the legislature would escape the scrutiny of the courts. However, judicial review was viewed as part of the basic structure of the Constitution, and the amendment could not bypass the powers of the court to scrutinize laws, including the constitutional amendments. The court also held that harmonizing the fundamental rights as provided under Part 3 and the directive principle of state policy as provided under Part 4 of the Constitution are also parts of the basic structure of the Constitution. And now we'll discuss another important ruling, and that is relating to Madras Bar Association versus Union of India in 2014. The issue before the Honorable Supreme Court were threefold. Firstly, the constitutional validity of the NCLT and NCLT on the grounds that it violated the basic structure of the Constitution. Secondly, the prescription of qualification, including term of their office and salary allowance, etc., of president and members of the NCLT, and as well as the chairman and members of the NCLAT, and lastly the criteria for selection of the committee for appointing the members of both the tribunals. The Supreme Court did not accept the contention of the petitioner. It was held that the NCLT and NCLAT are compliant with the basic structure of the Constitution as it was in consonance with the separation of powers, judicial review, and independence of judiciary. The Parliament is empowered to create a law which transfers a judicial function on a specific subject to any tribunal, given that tribunal shall follow the principles of natural justice and the provisions of the Constitution. Additionally, the jurisdiction of the courts can be shifted to tribunals if it would abrogate the pendency and delay. Thus, NCLT and NCLAT were held to be constitutionally valid. And now we'll discuss another important leading case, and that is relating to Supreme Court Advocates on Record Association versus Union of India in 2016. One of the very recent cases on the basic structure, and as relating to this was National Judicial Appointment Commission case, or famously called the Four Judges case. By virtue of the 99th Constitutional Amendment, the Parliament replaced the then mechanism of selection of judges with the National Judicial Appointments Commission. The initial composition of National Judicial Appointment Commission was thought to be comprising of Chief Justice of the Supreme Court along with four senior most judges of the Supreme Court. However, at the time of enactment of the National Judicial Appointment Commission Act, the commission was composed of the Union Minister of Law and Justice and two eminent persons alongside Chief Justice of India and two senior most judges. So the petition were filed challenging the constitutionality of amendment and National Judicial Amendment Act, raising the serious concern that the impugned law affected the independence of judiciary and caused lack of transparency and accountability. So by majority view, the apex court held that the said amendment and act were violative of the basic structure doctrine, since it affected the independence of judiciary by including the executive in the selection process of judges. The court was of the view that the impugned laws goes against justice. Chalmers source opined that the judicial precedents, those were set in Kesavananda Bharati and Minerva Mills case. So, also, we discuss another important leading case, and that is relating to the basic structure of the Constitution. So, in that regards, we have to discuss the first important leading case in relation to basic structure laid down by the Andhra Pradesh High Court in 2002 relating to Bhimi Reddy versus Srinivasul Reddy, where the Andhra Pradesh High Court deciding whether the non-disclosure of criminal cases by an electoral candidate would render the election result as void, as the basic structure of constitution was resorted to. It was held that a free and fair election is a basic feature of our democracy, hence the basic structure of the Constitution. And now we'll discuss the judgment of Supreme Court in relation to All India Judges Association Union of India in 2023. The Honorable Supreme Court has reiterated that the independence of the judiciary is a part of the basic structure of the Constitution, and it includes the independence of the district judiciary as well. And now we'll discuss another important leading case, and that is State National Capital Territory of Delhi versus Union of India in 2023. Supreme Court expressed that the federal model of government in India, especially in case of the National Capital Territory of Delhi, the issue was the constitutional validity of Article 339 A double A Clause 3 Subclause A of the Constitution. The Constitutional Bench of the Honorable Supreme Court held that interpretation of Article 339 double A Clause 3 Subclause A is an expansive manner and would further basic structure of federalism. So, now we'll discuss the very important leading case, and that is a kind of debate on National Judicial Appointment Commission, and that was discussed. So, in the very argument made by the critics related to the fact that National Judicial Account Committee Act did not affect the independence of judiciary. Moreover, a question is raised in this regard on how the collegium system is necessary for the independence of judiciary. Referring to the 2015 verdict which had involved the basic structure theory, the Vice President of India, Honorable Jagdeep Dhankar, addressing the 83rd All India Presiding Officers Conference, remarked that the scrapping of National Judicial Appointment Commission Act was a scenario perhaps unparalleled in the democratic history of India. According to him, parliamentary sovereignty and autonomy cannot be permitted to be compromised by the executive or judiciary. Another aspect on which the basic structure is criticized is that the structure is not defined properly. The way the basic structure functions can be referred to as the ex post review mechanism. Under the mechanism, since the contents of the basic structure are not defined or fixed, it comes to picture as a review mechanism after the amendment is implemented. This is because the function of the basic structure is to keep a check on the impact of the socio-economic and political circumstances of given times at which the amendment comes into effect. As a result, the basic structure excludes the legislative and executive functions from its scope, giving space to ambiguity and raising an important question whether basic structure should be confined to amendments to the Constitution only. More specifically, apart from the other criticism, the critics also question the judicial power to impose its philosophy over a democratically elected government. More specifically, the question is related to judicial overreach, as the Constitution does not empower the judiciary to abrogate any legislative action. So, now we'll go to the very conclusion, and that conclusion is relating to the basic structure doctrine as it evolved in India from the most famous and outstanding and important leading case, that is Keswananda Bharati versus State of Kerala. So, in that connection, we would like to review the entire issue concerning judicial review and the basic structure doctrine in our concluding portions. Although it is true that the basic structure doctrine provides an overhauling power to the judiciary, it is pertinent to note that the Indian Constitution has been drafted with a pious and sacred intent. The makers of the Constitution endowed the responsibility of protecting the true values of the Constitution upon the judiciary. Thus, the judiciary has to protect and uphold the true values of the Constitution above everything surrounding it. If these values themselves are amended by the legislature, it would be detrimental to the spirit of the Constitution. These values are what form the basic structure of the Constitution. However, the biggest problem faced while protecting the basic structure is that it has not been clearly defined. As discussed above, the basic structure is also found in various other democracies. Since the scope of basic structure is defined in those constitutions that we already have discussed regarding the German constitution, French constitution, Greek constitution, the Portuguese constitution. So the scope of criticism is limited, thus a definite basis of the basic structure is the very need of the hour to let a final rest to those criticisms and controversies raging regarding which portions of Indian Constitution are falling under basic structure doctrine. So, we have completed the lecture on this very important doctrine relating to not only the Constitution of India but also to some other important constitution relating to some other democracies in the world, and that is doctrine of basic structure.